Hello, and welcome to UK Employment Law, the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights recent case law and legal developments of importance to UK employers. It is presented by members of Mayor Brown's employment team and occasionally features special guest speakers who are involved in changes in employment law. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions. We hope you enjoy the podcast.
Hello everyone, and welcome to the Mayor Brown Employment Podcast. In the last episode, I spoke about two cases that were relevant to the COVID pandemic and the steps which many employers are taking to bring employees back to the workplace as the various lockdown measures are eased. In this episode, we have another two cases which are similarly relevant. The first is a case where an employee was dismissed because of upset and friction caused by the way in which he was carrying out certain health and safety responsibilities he'd been given at work. The question there being whether the dismissal was automatically unfair because of the special protections around health and safety dismissals. And the second case concerns an employee who refused to agree changes to her contract of employment that her employer wanted to impose in connection with the pandemic, and whether the employer could fairly dismiss her in those circumstances. So, the first case, which is Sinclair versus Trackwork Limited. As I say, this is a case all about the special health and safety provisions that are contained in the Employment Rights Act, specifically Section 100. You'll remember from the last episode the case of Rogers and Leeds laser cutting, which concerned another limb of the Section 100 protection, which is where an employee is terminated in circumstances where they believe there are serious and imminent dangers at work. And you'll remember that Mr. Rogers said he had to stay away from work because of his concerns about the COVID pandemic. The Sinclair case looks at another limb of the Section 100 protection, where an employee who has been given special health and safety responsibilities at work. Mr. Sinclair was employed as a track maintenance supervisor for Trackwork, and one of his duties was to implement the Trackwork safe system of work procedures, which was based on a procedure implemented by Network Rail. It seems from the evidence that Trackwork's intention was for the new process to be introduced gradually, but they had not told Mr. Sinclair this, and he proceeded to introduce the changes with rather more zeal, shall we say, than the employer had perhaps intended. The upshot was that the other employees found the changes difficult to deal with, and the forceful way in which Mr. Sinclair introduced the changes caused some friction. And this led to the employees making a complaint to management, and that in turn led to Mr. Sinclair's employment being terminated for the upset he was causing. So he claimed automatic unfair dismissal on the basis that the reason for his dismissal was the health and safety duties that Trackwork had given him. Trackwork said that wasn't why they had dismissed him. It was not the fact that he was carrying out those activities, but the way he was carrying them out. And that was different, they said, from the protection that was intended to be given by the statute. And initially, when the case came before the tribunal, Mr. Sinclair lost his case. The tribunal agreed with Trackwork. They said it was not the carrying out of the health and safety duties that caused Trackwork to dismiss Mr. Sinclair, but the fact that the workforce was becoming demoralised by the way in which he was managing his health and safety obligations. Mr. Sinclair appealed, and the EAT came to the opposite conclusion. They said Mr. Sinclair had not exceeded his mandate in implementing the health and safety procedures. It was simply his colleagues' perception of his approach as being overzealous that caused the friction and upset between them. The court said that this was exactly what the special protection in Section 100 was designed to guard against, i.e. the fact that carrying out these sorts of health and safety activities will often be resisted or regarded as unwelcome by other colleagues. But the protection will be completely undermined if employers could rely on upset caused by legitimate health and safety activities as grounds for dismissal. So they found in favour of Mr. Sinclair, and his unfair dismissal claim was upheld. So perhaps not an unsurprising case on those facts, but you can see examples of times when employees may overstep the mark in their health and safety activities. And the EAT did say that where that was the case, then the outcome may be different. In this case, there were various allegations made about Mr. Sinclair's behaviour, which Trackwork said were the real reasons for his dismissal, but none of those allegations were made out by the tribunal when they analysed them. And as I say, as far as his health and safety activities were concerned, there was no finding that Mr. Sinclair had gone beyond his remit in what he was doing. So, along with the Rogers and Leeds laser cutting case from last time that we looked at, this is another example of the Section 100 protection coming into play, this time highlighting the protection which relates to employees who are given health and safety roles. And as we know, everyone has different views on what are appropriate health and safety measures related to the pandemic. For example, how best to make office premises safe and secure. And as employers start to bring employees back to work, it may well be the case that upset and friction will be caused. The Sinclair case is a good reminder for employers to make sure they take steps to protect employees who are tasked with implementing health and safety measures. Otherwise, they will run a risk of claims under the Section 100 protection. So, that's Sinclair and Trackwork. My second case is the case of Khatun versus Winn Solicitors Limited. It's only a tribunal decision and so not binding, but it's certainly relevant to an issue many employers have grappled with and no doubt will continue to grapple with. It's a fire and rehire case, well, sort of. As most of you will probably know, the fire and rehire process is sometimes a way in which employers can drive through contract variations instead of obtaining the employee's agreement. The idea is that instead of making a unilateral change to the employee's contract, which would probably be a breach, the employer terminates the contract altogether and offers a replacement contract that contains the new varied terms. In that way, the employer avoids a breach of contract claim, and they should also avoid an unfair dismissal finding based on the some other substantial reason defence to unfair dismissal claims, which is the catch-all defence, where an employer has a good business reason for making the dismissal. Now, the COVID-19 pandemic has seen this mechanism used by employers where they have needed to make changes to employees' terms, whether that's to put them on furlough or make changes to their working hours or pay. And there are recent high-profile examples of the mechanism being used which have received adverse publicity, and there has been a call by some to outlaw the fire and rehire process. But for now, it survives, and the Khatun case is a good example of it being used in the COVID-19 scenario. The facts of the case were that Ms. Khatun worked for a firm of solicitors that specialised in personal injury claims. When the pandemic hit in March 2020, the firm could see that it was going to need to make some drastic changes very quickly because they were predicting a dramatic downturn in the volume of work that they would see coming in the door. So they did two things. First, they placed a number of staff on furlough, and secondly, they asked the remaining staff to agree to a variation in their contracts, which said that they would consent in the future if they were asked to go on furlough or to have a reduction made to their working hours and correspondingly their pay. The facts of the case suggest that all of the employees at the firm agreed to the variation, except Ms. Khatun. She said that she would be happy to consider going on furlough or taking a reduction in pay and hours in due course if that became necessary, but she did not want to agree in advance that the firm could make that change whenever it wanted. The firm did not accept that position, and Ms. Khatun's contract of employment was terminated. She brought a claim of unfair dismissal, and the firm's defence to that was to rely on the some other substantial reason defence, i.e., it had sound business reasons for the change and the dismissal was due to those reasons. So the tribunal had to look at two things in order to decide the case. First was whether the firm had shown that there was a substantial reason to justify the dismissal, and on that point, the tribunal found that there was. In the circumstances of the pandemic, they were satisfied that the firm had good enough reasons to require the changes in contract that it had requested. And interestingly, it didn't matter that this was at a very early stage of the pandemic where the firm's actions were based on a predicted downturn that was yet to come. And even though it turned out that the predicted downturn was not as bad as they had in fact expected. But the second limb was where the firm fell down, i.e. the requirement for the employer to act reasonably. The tribunal accepted that the circumstances of the pandemic meant that the firm could not have carried out a lengthy consultation process, but in Miss Khatun's case, they had only allowed a period of 48 hours between requesting the variation and terminating her employment. There was only one meeting, one phone call, and a handful of emails. It was also clear from what the firm was saying to Miss Khatun that they had made their mind up that dismissal was the only alternative to the variation. There was no sign of any meaningful consideration of the points Miss Khatun was making. And as I said earlier, normally what an employer would do in this situation would be to offer the employee a replacement employment contract which contains the variation the employer has requested. The employer then issues notice of termination under the current contract and offers the new contract to begin when that notice period has expired. In this case, the firm didn't offer any replacement contract and they terminated Miss Khatun's employment without notice or any payment in lieu of notice. And finally, the tribunal pointed to the fact that there was no appeal offered against the dismissal. The judge said that he was aware that the ACAS Code of Practice, which requires appeals to be offered in disciplinary dismissals, does not apply to SOSR dismissals, but, he said, he thought it was a relevant consideration in determining the reasonableness of the dismissal in this case. And so, all in all, Miss Khatun's unfair dismissal claim was successful, and it's an interesting case given employers will perhaps have to consider the fire and rehire process as employees return to work and changes to contracts are required, for example, to their place of work and working patterns or hours of work. The case is helpful, certainly for employers, in confirming the availability of the SOSR defence to an unfair dismissal claim in such circumstances, but it is also a reminder that the tribunal will expect some sort of reasonable process, some sort of consultation with employees to be carried out. And I think that will be all the more so with changes made in relation to a return to work, where employers will have had more time to prepare than when the pandemic first took effect last year. So that's Khatun and Winn Solicitors. And that's the end of this episode of the podcast. I hope you found those two cases interesting. And as always, if you have any questions or comments, please do contact us. In the meantime, stay safe and well, and I look forward to speaking to you next time. Bye for now.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Christopher Fisher, Head of Mayor Brown's London Employment Team, at cfisher@mayorbrown.com. Thank you for listening to the podcast.